Put your ballots here. No blacks or women can vote.
Thank you.
Hey, can I vote? No, leave. You haven't earned that right. Leave.
The writers of the 15th Amendment first produced three different versions of the amendment. The first version stated that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on any account of race, color, or previous condition of servitude. This is the version that was ratified on February 3, 1870. The first and chosen version was the most lenient, while the others were very specific and did not allow for discrimination based on literacy, taxes, or residency. The Southern states were not yet a part of the Union, and the ratification of the 15th Amendment was a requirement to join with the Union. However, white Southerners were able to continue weighing down African Americans through poll taxes, residency requirements, and literacy tests, and so the promise of the 15th Amendment was not fully recognized until after the Voting Rights Act of 1965.
Next in line.
Come vote. Come put in your ballots, please. Here you go, sir. Right in here, sir. Thank you.
The Voting Rights Act of 1965 was necessary when Southern Democratic states started to ban blacks from voting for reasons outside the control of the 15th Amendment. However, in 2006, just 6 days after the President signed the renewal of the Voting Rights Act, the Northwest Austin Municipal Utility District No. 1, or NMUDNO, filed a case stating that the Voting Rights Act was unconstitutional and was no longer necessary. NMUDNO, a local authority that regulates water services and park maintenance, sought to escape Section 5 of the Voting Rights Act. Section 5 states that jurisdictions with a history of racial discrimination must receive federal clearance before any changes in voting laws can take place. NMUDNO's major argument was that the conditions that caused Texas to be covered under Section 5 have long been remedied. However, in May of 2008, a federal court upheld the Voting Rights Act, rejecting NMUDNO's claim to be exempt from Section 5 enforcement.
Can I see some identification? You're good. Thank you. Next in line. Identification, please. All right, you're good. Next in line. Identification, please.
I don't have identification.
Then you can't vote. Sorry.
Recently, on October 2nd, there was a major court case regarding voting and the Voting Rights Act of 1965. In Pennsylvania, a judge did not allow a highly contested state law requiring strict photographic identification to vote. Luckily for Pennsylvania citizens, they will not have to present an approved ID to vote. Not only is this a major dispute in Pennsylvania, but in other states around the country, dealing with voter ID requirements, early voting, provisional ballots, and registration drives. This reflecting back on the Voting Rights Act of 1965, when loopholes for preventing certain people from voting were abolished, and now it is coming back. There are strict voter ID laws that are currently remain in Kansas, Indiana, Georgia, and Tennessee. This new law in some states is not directly aimed at a certain type of people, but a majority of people who are poor or in a financial crisis and do not have identification. So although this new voter ID law does not break the Voting Rights Act of 1965. It is very close to it and does not make people happy. Liberal-leaning and civil rights groups are directly challenging these rulings around the country. People believe that they are a citizen of this country, that they should be able to vote, whether they have an ID or not.